Good afternoon, everyone. Thank you for joining us for today's webinar, Educating and Advocating in Manitoba's Prisons, part of the 2024 Access to Justice Week series of events in Manitoba. I'm Allison Fenske, and I'm Clinical Counsel with the University of Manitoba's Faculty of Law. As part of my role within the faculty, I'm also the director of the University of Manitoba Community Law Centre, which includes a pilot prison law clinic. Today's event is being hosted by the Law Society of Manitoba, the Manitoba Bar Association, and the University of Manitoba Faculty of Law from the original lands of the Anishinaabe, Anishinaabe, Dakota Oyate, and Dene peoples, as well as within the national homeland of the Red River Métis. So we acknowledge the folks that have allowed us to gather here today and work in those relationships of reciprocity, while also recognizing that in a topic such as this, it needs to be stated the overwhelming overrepresentation of Indigenous peoples in the carceral system and the need to address that. Today's topic is scheduled for 1 hour and 30 minutes. Audience questions are welcome. To submit a question, we're using the Q&A function. So in the bottom of your Zoom window, you can type into the Q&A box. We're going to plan to hold the questions until the end of the presentations, but please pop them into the Q&A as they occur to you. We may be able to address quick clarifications along the way as we move towards a broader question and answer at the end of the panel. The chat function can be used to report a technical issue, but it's not going to be monitored for questions. So again, please use that Q&A box. I'm pleased to welcome our presenters today. For more robust introductions, you can check out the Manitoba's Access to Justice website at mbaccesstojustice.ca. Everyone's bios are posted there, along with a wealth of other access to justice information. So if you haven't had an opportunity to check out that website before, it's a great resource. By way of brief introduction, in the order that folks will be presenting, we have Liz McCandless. Liz is Senior Instructor and Director of Clinical Programming at the Faculty of Law, University of Manitoba. Prior to joining the faculty in 2022, Liz served as Director and Legal Counsel for the Manitoba Law Reform Commission. We also have Kirsten Werman, who is a librarian with the Manitoba Law Library. She has volunteered inside carceral institutions for over 17 years and is the founder of the Manitoba Library Association's Prison Libraries Committee. Welcome, Kirsten. We also are joined by Mark Cruz, who's the Director of Indigenous Legal Learning and Services at Robson Hall and an associate with Restick Rogoa Law Offices, where he practices criminal defense work. And last but not least, we have Leif Jensen. Leif is a staff lawyer with the University of Manitoba Community Law Centre's Prison Law Clinic. And in his time in legal practice in Saskatchewan, British Columbia, and Manitoba, Leif's worked with hundreds of incarcerated people within the realm of prison law. Excited to have these really knowledgeable folks gathered here today. And with that, we'll turn things right over to Liz.
All right, thanks very much, Allison. Okay, so my part of this presentation relates to educating in Manitoba prisons. And just by way of introduction, I first got involved in libraries and prisons projects through my role as a supervisor for the Rights Clinic course. And the Rights Clinic course is a third-year course for law students where students conduct research and writing on rights-related issues, often with working with community organizations. So for this project, we teamed up with the Prison Libraries Committee in Manitoba, and there were two parts to this project. The initial part was we had law students conduct a legislative scan to see how other jurisdictions in Canada legislate or don't in relation to the provision of libraries, books, legal resources in correctional facilities. So just a shout out to the students that conducted that research, Maria Manzano Garcia and Lizzie Tuff, and as well as contributions from Sienna McElwraith Fraticelli. So the first part of my 10 minutes is speaking about the Canadian legislative landscape for libraries and prisons and access to legal information for people who are incarcerated. After that, I'll just briefly touch on a project that law students are currently working on to help bridge the legal information gap for incarcerated people. So why do we need libraries in prisons? Well, I think the backdrop to this discussion is Rule 40 of the United Nations Standard Minimum Rules for the Treatment of Prisoners, otherwise known as the Nelson Mandela Rules. And Rule 40 states that every institution shall have a library for the use of all categories of prisoners, adequately stocked with both recreational and instructional books, and prisoners shall be encouraged to make full use of it. So although the Nelson Mandela rules are non-binding, Canada has committed to implementing these rules and has accounted for them when drafting federal correctional policy. So just to clarify, so federal institutions in Canada, this is for incarceration of convicted offenders that are sentenced to 2 years or more. And federal institutions are for the incarceration of people who have been sentenced to less than 2 years and people who are being held in remand. So I'll just first touch on currently what's happening at the federal level and then the provincial level. So at the federal level, the Corrections and Conditional Release Act states that all federal prisons in Canada must provide a range of programs to assist in the successful rehabilitation and reintegration of incarcerated people. And to that end, in 2012, the Correctional Service Canada compiled the National Guide for Institutional Libraries, which states that federal institutions should have access to library services that are similar to those offered in the community. The policy provides that the purpose of a library in a federal institution is to provide access to a wide range of information, ideas, and perspectives. And it further says that libraries should have materials which reflect the diverse ethnic, linguistic, and cultural heritage of the correctional community in the region where the library is situated. So this is what we have in the federal policy. Put into practice, what we see is that the services offered throughout the country are sometimes uneven, but that's what the Act and the policy have to say about that. And so at the provincial level, what we see is that in many provinces, there is no legislation pertaining to libraries in prisons. And the provision of resources and books and prisons is really a patchwork of volunteer organizations. In Manitoba, most provincial correctional facilities now have access to library materials because of the ongoing work of the Prison Libraries Committee, which we'll be hearing more about the great work of the committee from Kirsten, who will be speaking after me. So just briefly, what is the state in other places in Canada? Well, in 2018, Ontario passed legislation relating to the establishment of libraries in correctional institutions. And so the Correctional Services and Integration Act 2018 has some really good stuff in there. It says in Section 60, every inmate has the right to borrow books in accordance with the regulations. Section 90 says the superintendent of a correctional institution shall establish and maintain a library or equivalent system, which may include an electronic library or database that is accessible to all inmates. And then it goes on to talk about the contents of the library. So this is a very positive step, but unfortunately, passed in 2018, the statute is still not yet in force, and there's no corresponding regulation. So it appears that the political momentum for putting these changes in place has waned, and currently Ontario is still dependent on volunteer network and organizations like the John Howard Society. So just very briefly, the rest of the country, there are some provinces that have policies in place with respect to libraries and prisons, like BC. Other provinces like New Brunswick and Nova Scotia have regulations that provide for the creation of policies. And then in the territories, in Northwest Territory, the Corrections Act provides access to reading materials is considered a minimum living condition and standard. In Yukon, the regulation under the Corrections Act provides that inmates have a right to access reading materials. So some positive stuff in the territories. So all of the provinces that I didn't mention have not yet implemented anything in the legislation as of yet. As I say that, this will be a good segue once I'm done to some potentially promising news from Kirsten on the Manitoba front, but currently nothing in place in the other provinces, so really relying on volunteers. And I just wanted to touch on, there's limited case law in this area, but there is one case that I wanted to mention, and that's RV Beaver, B-I-E-V-E-R, which is a 2015 Alberta decision. And in this case, there was an accused who was self-represented, and he was incarcerated, and he brought an application seeking full access to legal materials, processes, and any case law the defendant may require to make full answer in defense. And so Justice Grazer considered this at the Queen's Bench level, and Justice Grazer found that the accused was entitled to access criminal law textbooks and internet access for CanLII specifically. So for those of you who aren't necessarily lawyers or went to law school, CanLII is a free legal research database where you can access case law, legislation, commentary, that kind of thing. So Justice Grazer said that the accused was entitled to access CanLII and criminal law textbooks, but not Westlaw or Lexis Plus, which are the paid services. And in the decision, Justice Grazer said, "I am satisfied that Mr. Beaver will likely be unable to make full answer in defense to the charges he faces if he is not provided with greater access to legal information than he presently has." But Justice Grazer goes on to say that this decision is not intended to be a manifesto for the creation of generally available law libraries in remand centers or prisons. It is not unreasonable for budgetary considerations to have reasonable limitations in place. And so he wasn't willing to go that step, sort of showing deference, noting that that this is really up to government to make these sort of calls. So just to conclude on this point, regardless of a lot of provinces' lack of legislative guidance in this front, volunteer associations nationwide have sought to provide library services to inmates. But what we would like to see is, further establishment in the legislation so that you're not kind of at the whim of the government of the day as to whether this should be something that's provided for. Now, before I leave you, just in the last minute that I have, I just wanted to tell you about another project that the Rights Clinic students are currently doing and have been doing. This is their second year. So we have a group of Rights Clinic students who are working to provide answers to legal information questions for people who are incarcerated. So we receive legal information requests from people who are incarcerated via Kirsten Werman and her network. And students conduct legal research under the supervision of a lawyer, aka me, or I refer it to a colleague if it's about an area to which I don't have as much knowledge. And the students prepare a memo, and then they turn it into a plain language one-pager. And so this one-pager essentially sets out their answer to the legal question that the person may have. It's only in relation to legal information, not legal advice. Some of the topics that students have covered are things like no contact orders, appeals, legal aid appeals, child protection laws, voting rights for people who are incarcerated, understanding the Human Rights Code. So things like how do I apply for a job if I have a criminal record, those kinds of things. And so the information goes back to the person who requested it. But in this way, we're also creating a library so that this information is more widely available to others that may have the same questions. So that's it for me. I'm happy to answer any questions that you may have at the end of everybody's presentations. And so thank you very much.
Thank you so much, Liz. That was a great foundation to understanding the access to legal information, or in some ways, a lack of access to legal information in our prisons. And with that, I will turn things over to Kirsten Werman.
Okay, and I'm going to share my screen. Okay. All All right. So yes, my name is Kirsten. I am a white settler of European descent. My pronouns are she, her. I am a librarian, not a lawyer. And the work that we do with the Prison Libraries Committee happens on Treaty 1, Treaty 2, Treaty 3, and Treaty 5 territories and the homeland of the Red River Métis. We are really grateful for the lessons that we are learning throughout this work that we're doing, but we acknowledge that we can always do better. What was promised, what has been promised, really remains unfulfilled. We are committed to working towards TRC calls to actions number 30 and 38 as they relate to lowering the high incarceration rates of Indigenous adults and Indigenous youth. And more recently, we've been working a bit more towards TRC call to action number 36, which speaks to providing culturally relevant services to inmates on issues such as substance abuse, family and domestic violence, and sexual abuse. We're also committed to the calls to action civic to all Canadians, 15.1 through 15.8 from the National Inquiry into Missing and Murdered Indigenous Girls, Women and Girls. So I'm just going to lay the foundation of needs as it relates to information access and legal information access in prisons. So I wanted to start with this corrections dashboard from StatsCan, which provides information about federal institutions, but also information about every province and territory. And this is for adult corrections and youth corrections. So as you might be able to see here, and you may be well aware, 75% of folks who are incarcerated are in remand, which, as you know, is supposed to be a temporary detention of a person awaiting trial or sentencing. But as argued by the John Howard Society, this is a cause for great concern, as those people who are found not guilty, which is about 35% of remand prisoners, end up serving time that cannot be returned to them. Also worthy to note, racialized people are more likely to get remand rather than bail compared to non-racialized. In 2021, Indigenous people were incarcerated at a rate 8.9 times higher than non-Indigenous people. And I think we would see that ratio is even higher in women's prisons. And you can see here, just even generally, the incarceration rates for adults in Manitoba is 160 per 100,000. Meanwhile, in terms of Canada-wide, in terms of the provincial system, it is 71. Provincially, Indigenous folks account for 18% of Manitoba's general population, but 77% of incarcerated adults in Manitoba institutions are Indigenous, and 84% of incarcerated youth in Manitoba are Indigenous. And federally, the statistics are just as dire. Indigenous, Black, and other racialized and marginalized people continue to fill prisons at a disproportionate rate. And this really points to the historical and ongoing colonialism that faces these justice-involved people and is linked directly to systems of discrimination and socioeconomic marginalization. I did want to also just speak a little bit, even though I don't have stats, about the range of intellectual and developmental as well as physical disabilities that one finds in prisons. Institutions don't really collect this data, so we don't know much in terms of stats, but we do know that 27% of the Canadian population over the age of 15 has at least one disability. And 40% of individuals with a mental health disability are arrested at least once in their lifetime. So even without statistics, it's not difficult to conceive of some of the obstacles that folks face in terms of accessible information, including legal information. On November 1st, 2023, the 50th annual report of the Office of the Correctional Investigator was tabled in Parliament, and the report includes the second of a two-part update to the office's original special report to Parliament that was titled Special Spirit Matters, Aboriginal People and the Corrections and Conditional Release Act. And in this report, Ivan Zinger, the correctional investigator, states that Canada's correctional population is becoming disturbingly and unconscionably indigenized. The correctional system seems to perpetuate conditions of disadvantage and discrimination for Indigenous people. Outside the context of a prison, I think we all can probably agree, based on our own experiences of visiting libraries, public libraries, academic libraries, that they provide a real variety of services and supports for communities. And for many of us, libraries are fundamental to our human rights. But inside Manitoba prisons, information poverty is more the reality. And it's really become more like information obsolescence, or even, again, from the correctional investigator, information depriving. So as Liz said, not all prisons have libraries. And I think that shocks a lot of people. I think most people assume all prisons have a library, just like in the movies. And as Liz said, there's no mandated directive in Manitoba to have libraries. And so what we find is that there are no real, what we would consider libraries. There's also no internet. There's a lack of current technology or computers, even just for data processing purposes. There's a waiting list, a long waiting list for school placements. There's a lack of access to legal information that might be particularly relevant to an incarcerated individual situation. And what we found in our experience is that access to the library or to information generally is treated more as a privilege for good behavior rather than a standard that all incarcerated people are entitled to. Of course, along with the information poverty and low literacy rates, this does nothing to help that incarcerated individual deal with the complexities of our very information-driven society that we live in. And nor does it offer access to the necessary legal information needed to understand and solve problems. There are, of course, many other challenges and barriers inside prisons, aside from information poverty and real library spaces. There's the issue of censorship. Of course, there are rules that we can't bring in hardcover books to most of the prisons. Nothing with staples. No true crime, nothing that glorifies sexual violence, hate speech, gangs, etc. That's fairly standard and sort of understandable. But most times these restrictions are not codified or even written down. So they can be made, these decisions, censorship decisions can be made quite arbitrarily based on a prison staff's personal bias, perhaps lack of knowledge about a book's content, or based on a paternalistic view of what an incarcerated reader should have access to. Big challenge is that there is little to no support, financial support from corrections for legal or library programming and services. So the Prison Libraries Committee wrote, along with some other prison library workers, we wrote a right to read statement back in 2016, and we updated it in 2024, and it has been adopted by the Canadian Federation of Library Associations. And this right to read statement really describes our guiding principles and values, and calls upon correctional institutions to actively promote literacy as a continuum of learning that assists and allows people who are incarcerated to develop knowledge and potential and achieve goals and participate fully in society. We start off our statement by saying incarcerated Canadians do not relinquish the rights and freedoms guaranteed to them under the Canadian Charter of Rights and Freedoms. We also say specifically that libraries in a prison can play a fundamental role in guaranteeing rights, not only by providing inmates with access to information about their own legal rights as incarcerated people, but also by providing the tools necessary to exercise these rights. Now, obviously, this is our right to read statement. It's not, it sort of states what we would love to see within prisons. But like I said, it guides us in the work that we do. And so fundamentally, we believe in access to information, to legal information, to books for everybody. And that includes members of the community who are incarcerated. I just thought now I'd take some time to speak specifically about the work that the Prison Libraries Committee is doing in Manitoba. So this graphic depicts the Winnipeg Remand Center in downtown Winnipeg. This is the only adult prison that is within the city limits of Winnipeg. There are 5 other provincial and 1 federal prison that are all outside of the city limits. The Prison Libraries Committee is a volunteer committee of the Manitoba Library Association. We started in 2012, so we've been operating now for over a dozen years. And we actually started in the Remand Center. But we now provide books and some sort of library programming and services inside every provincial prison, including the Manitoba Youth Center in Manitoba. There's no budget or funding for what we do, aside from the we're very grateful for the Manitoba Library Association that gives us $500 a year. But we do a lot of fundraising and book drives. So because of the federal directives that Liz was talking about, prisons like Stony Mountain here in Manitoba, they do have a library, and they have a library professional who works with and curates their collection, which is fabulous. And that's an important piece in the federal directive, is that it includes staff. Federal directives also outline what legal materials should be in all federal prison libraries. Also very, very important. So the work that we do with the Prison Libraries Committee is only inside the provincial institutions, because that's where we see the greatest need existing. So these learners, these readers, these incarcerated folks, they bring to the space their own knowledge and understanding about themselves, about their community, about the wider society. And this is really, really valuable. And we listen, we hear them, but that's not always the case within a carceral setting. So as you can see here, in the dozen years that we've been doing this work, we've been able to really see a huge diversity of needs, reading needs within the prisons. There's legal needs, lots of recreational needs, of course, recreational reading, lots of James Patterson, Dean Koontz, but lots of health books, pregnancy books are really important. Language learning, Indigenous language learning is incredibly important. And it's really hard for us to keep up with that need. Gabor Mate, any sort of book on addictions, is also very, very, very much a big need, as is any sort of Indigenous material. And lots of dream interpretation. I'm always just so surprised about that. We get a dream interpretation request probably, I don't know, once a week. So just very briefly what we do book collection and delivery for every single provincial institution. Again, we are volunteers. We have no funding. This is all donations. We get weeded books from public libraries, from book sales, etc. But we also are doing more fundraising so that we can buy some of these specific books, because Indigenous books are really hard to get donated. So we need to buy a lot of those books. We also provide program and services, which is a really important piece at all. It's not just, we can't just be providing the books, I believe. We also need to be in there and meeting with folks, talking to folks, finding out what they need, but also bringing in guest authors and artists who can tell their stories. And this has been a really, really positive and wonderful programming that we've been able to do to many of the prisons. And we do raise money so that we can pay these folks for sharing their knowledge with us. But it often really comes down to just almost creating just one moment. You know, we don't have a big library. Sometimes it's just like a moment between somebody to connect. And that could be about a story, about a book, but just sometimes that's all that we can do is just create that moment. And the work and experiences that I've had with the Prison Libraries Committee over the past dozen years really has taught me that personal act, that act of choosing your own book is a really powerful act of personal autonomy. And that the library experience, that moment, we try to provide a humanizing experience within that moment, something that really is not easily found in a carceral environment. I just want to now talk very specifically about two specific programs that we are doing. These are new programs. The first one that will be of interest, the Legal Information for Incarcerated Manitobans. And this grew out of an email reference service that we started during the pandemic, where folks emailed us through their teachers questions. And we started to see more and more legal information questions coming through to us. We also started to hear more from staff and other community organizations that we partner with, that there were more self-represented litigants within the prisons. We saw some really clear legal questions like, how does the legal system work? Just really some basic, like, what is an appeal? What makes a federal offense different from a provincial offense? But we also started to hear more broad or legally adjacent, what I call questions. So, what are the opportunities for me when I leave? I just want to learn all the information so that I know why we do bad things. Tell me everything that I need to know so that I don't screw up again. I'm not an animal. It would just be nice to learn more. Last week, I was just at the Headingley Correctional Center for the Community Resource Fair, and we we talked to 100 guys about our library, and one of them said, "Why don't all the units have a criminal code?" Good question. How can I get more information about CFS? Big concerns about custody. How do I get a new lawyer? So legal questions are constant. So the realization for this legal need really opened the door for Karen Zawatsky, who's the former director of the Manitoba Law Library, to advocate for funding back in 2023 from the Law Society to start a proof of concept project or initiative to look into this unmet legal information need. And I'm happy to say that this year we received a 3-year funding commitment from the Manitoba Law Foundation to continue this work and to expand our reach into every provincial prison in Manitoba. So from our research during the proof of concept phase, we came up with a list of legal materials and books that we thought should be, as librarians, that we sort of curated and thought should be in every prison in Manitoba. And with the Manitoba Law Foundation funding, we've now begun purchasing those collections and cataloging them in the Manitoba Law Library catalog. The first legal information collection was delivered to Milner Ridge in April. And the second one, Karen and I hand delivered to Brandon in August. We are also creating a digital library on USB sticks with PDFs and short legal information videos created by the Community Legal Education Association. And every Manitoba prison will receive these USB sticks that the teachers and literacy programmers, elders, chaplains will have on hand, and so that they can work side by side with folks as they work through some of their legal issues. Now, we've done all this, but a couple weeks ago, Leif Jensen, who you're introduced to, and he'll be speaking soon, contacted me about a client he had in Brandon, who said he's been trying for a couple months to get access to a criminal code and a book on appeals, and he said that he didn't know where to find that. Nobody seemed to know how to help him. And so Leif was asking how we could help. So this really is frustrating because, as I said, Karen and I delivered this collection with not one, not two, but 3 copies of the criminal code to share. And also, as I looked on our catalog, there was a book on appeals in a plain language book. So why was this person not provided this information? So that's a challenge. We can get the books to the prisons, but then that information has to be shared within the prison. We had delivered it to the literacy coordinator, to the assistant superintendent of programming, to the head of programming for custody and corrections. They were all there, but they need to get that information out to the rest of the staff and to the incarcerated individuals themselves as well. So aside from the lack of books, we also realized that there was not a lot of Manitoba-centered legal information for incarcerated people. Certainly not in plain language or in accessible formats. So Liz was describing the FAQs that the rights clinic students are creating for us, which are fantastic. We're also working with other partners on presentations. We're doing lots of advocacy, and we've got still a couple years, and we have plans for Pathfinders, infographics, and a graphic novel as well. Partnerships, always a lot. But we must consider, within the context of providing or trying to provide legal information to incarcerated folks, that prisons are, extremely racialized spaces, and we have to recognize the ongoing colonial history and systemic racism within all of these institutions, prisons, libraries, universities. So we have to consider Indigenous ways of knowing and being. And again, I point to our Prisoners' Right to Read that really identifies that responsibility. So quickly building on this idea, I wanted to just quickly introduce you to Joe Big George. He worked in a variety of prisons in Manitoba. He was a well-loved, respected elder. He was formerly incarcerated. He believed in the value of books, and he died in 2023. We were approached by his partner, Joanna White, and we are now building a memorial collection built with community, with the Prison Libraries Committee, and with Joe's own loved ones, to help fulfill his belief in the value of books by Indigenous authors, histories, and cultures as being critical to help so many of these incarcerated folks know more about their identities. So information literacy within the context of the justice system is so important when speaking on issues of Indigenous justice. And I really believe that folks would be better able to cope and understand their legal options if they also had an increased literacy and increased access to information about their own cultures and histories and art. So I do believe that a collection like the Joe Big George Memorial Collection needs to sit side by side the legal information collection. So 1 month after we delivered the legal information collection to the Milner Ridge, the Prison Libraries Committee also delivered our very first Joe Big George collection to Milner Ridge. And we were just there in September, and we could see both of these collections well used side by side, along with the recreational readings collections as well. I have 1 minute left, and I know this is not a great update on the provincial policies for prisons and libraries. We met with the Minister of Justice and the Commissioner of Corrections. I got a phone call from the minister's office, very excited a couple of weeks ago, saying that the minister had signed a policy that was modeled on the federal directive regarding prisons and libraries. I think the minister's assistant was a little hasty in his excitement. Karen and I met with the Commissioner of Corrections yesterday. Nothing has been signed. It's a draft. I'm a little concerned about how much of effect it will have. However, we will be included in a meeting for the final draft before it's presented to the minister to offer our comments, which is excellent. I know that the federal directive includes a list of legal materials that must be found in every prison, and I'm going to make sure that such a list is also included in that policy as well. We will keep you updated on our progress. And that is it for me. And I will pass it over to our
Thanks, Kirsten.
yes.
Just before you wrap up, there was a quick clarifying question before we get
Oh, sure.
to Mark. When you were speaking about the dashboard and the statistical information available, Victoria Perry asked, were you able to find incarcerated Indigenous identity as disaggregated by Indigenous group? I did a
No.
quick poke around and I didn't see it, but I wanted to double check with you.
No.
Okay.
Unfortunately, but not surprisingly, not. Yeah.
All right. Thank you very much. And thanks for your insightful presentation, Kirsten. The Prison Libraries Committee is doing great work. Over to Mark.
Good afternoon, everyone. Mark Cruz, he, him, English, Irish, and Soto from the Muscogee First Nation near the Fort Capel region in Saskatchewan. I have a few minutes to discuss some of the things that my office is assisting on in this space. So we have a third-year externship. We've partnered with Cochrane Sinclair Law Firm, and we've created a record suspension clinic and a status application clinic. And through that externship, I also take our students into high schools and into communities to give sort of mini information lectures on different legal topics. I'm sort of joining this panel in part to discuss some of the work that we're trying to assist on the prisons libraries as well. So as part of my directorship, I also have access to some research assistants. And so my research assistant, Janelle Jackson, has been working on specific areas around the Corrections and Release Act and how that relates to Indigenous offenders. As Kirsten noted, all of this work and all of my work is guided by the Truth and Reconciliation Commission, as well as UNDRIP and the Murdered Missing Indigenous Women and Girls and Two-Spirit report. So just a reminder to everyone that the TRC calls to action relating to justice are 25 to 42. In this space, we were looking at parole and some of the calls to action, and then how that's been picked up by the federal government in their acts. So call to action 31 is that they call upon the federal, provincial, and territorial governments to provide sufficient and stable funding to implement and evaluate community sanctions that will provide realistic alternatives to imprisonment for Aboriginal offenders and respond to the underlying causes of offending. As the stats were shown in the last presentation, Gladue and IPLE and all the work we've been doing on that hasn't really ameliorated the over-incarceration of Indigenous peoples. So we do need to do better. Part of our research was to review healing lodges and other Indigenous spaces that offenders could potentially be released to. We have a few in Manitoba, but a few other healing lodges across the country. So we're now trying to take all the research and put it more into plain language and create step-by-step instructions for offenders. Moving on from that, the TRC call to action 36 is calling upon the feds, the province, and the territorial governments to work with Aboriginal communities to provide culturally relevant services to inmates on issues such as substance abuse, family and domestic violence, and overcoming the experience of being sexually abused. Part of the information process in libraries and having books on these topics is part of that process. It is unfortunate that inmates are still not getting access to that information, but there is a positive obligation, I think, on our government and for us lawyers to educate ourselves on what resources are available as a defense lawyer for my clients, or for the Crown, even as we're crafting bail conditions or thinking about reintegration into the community. And I think part of that funding call to action is also calling on the feds in the province to help create these spaces, to create more healing lodges, to create more opportunities for something like sentencing circles to be facilitated by different nations. As the last question just noted, often we still have a pan-Indigenous approach to these information sessions or to the programming that's being developed, but we really do need to have specific cultural programming as well. So I know, Victoria, and that question was about the Inuit and how many of those folk come through our corrections system and through our justice system who don't have any real supports, because we don't have any Aboriginal justice workers that would help facilitate that or have that identity. And so it's really trying to find ways to expand options for our Indigenous offenders who find themselves in corrections. So there has been some updates to the Corrections and Control Release Act. Sections 81 and 82 specifically speak to corrections and the minister working with Indigenous communities and Indigenous agencies to help create release plans. So that is what a lot of the research that my assistant has been doing is just focusing on Section 81 sub 1 of that Act and Section 82 sub 1 of the Act, calling on for a national Indigenous advisory committee that might help establish regional and local Indigenous committees, which will help corrections integrate Indigenous offenders back into community. So that's part of the step-by-step guide, because as offenders are coming up for parole, they need to start creating a plan, which means that they or someone else needs to reach out to community, start engagement. Can they come back home? If they do come back home under release, what kind of conditions would the community like to see? What kind of programming is in the community for offenders? And this is really a space where I think the calls to action and some of this work can have some extra synergies to support communities as a whole. So as noted, with so many Indigenous people incarcerated, the state is still controlling Indigenous bodies, extracting them from communities and housing them in these correctional facilities. And there isn't really a pathway back from the correction institutions into community at this point. So we really just take Indigenous bodies away from community, away from their supports, and don't really find a way back. And unfortunately, many Indigenous communities don't have the support on their nations for addiction services or for education programs or for healing lodges. And so that's another portion of this is as we're trying to assist the inmates, we need to assist Indigenous communities themselves. So some of the work that I'm doing out of my office is to talk about justice centers. There's been a lot of good work out of the BC Justice Centers and some of the work they're doing to take over some legal aid services, to provide cultural competency training at these centers, to have wraparound services, really to be a connection for community as well. So these centers are typically in city spaces next to court, and they can be that connection to nations. Because outside of all of this, like who in corrections is actually connected to community? If someone's trying to, even a lawyer, assist an inmate, how do we get them connected to the right people? So again, using the Nunavut example, we have a lot of offenders that come down and can get lost in the remand center without supports because lawyers don't know who to call. Some of those communities are very small and only have 200 to 300 people in them. So as we're trying to develop bail plans or parole plans, who do we contact? So these are some of the information lists that we're trying to gather as part of this larger project and some of the projects coming out of my office as well. So we are in development of some justice centers. The first one would be an Inuit Justice Center. We've already had a summit on that. And Victoria Perry and I and some students just presented at the Indigenous Bar Association conference on some of our goals and hopes for that project. But these are sort of the services and things that we need as well. We need more justice centers, more wraparound supports, and more information for not just our offenders, but for corrections and for lawyers, and also for our politicians, because we need to get these projects funded and make sure that we're developing them with community and not just from the outside. So a lot of the library's projects reaching out to community and developing and hearing from offenders what they need is really a strong basis for a lot of this work. And I think I can stop there, but if anyone has any questions, we can put them in the chat. But we do have a lot of interesting things happening at Robson Hall, and we're trying to integrate these knowledges for our students as well. So in our mandatory course this week, we're actually going to be talking about justice, and we're going to be raising some of these issues with all of our students so they're alive to that while they're in law school, and while they're learning, know that these are some areas that they need to be knowledgeable on, especially if they decide to start practicing in criminal matters. So I'll stop there. Make which.
Hey, thank you so much, Mark. Our last presenter before we get into an open Q&A is Leif Jensen. Leif, go ahead.
Thank you. So what I'd like to do is talk a little bit. First off, thank you everyone for coming. My name's Leif Jensen, he, him, settler. I'll be talking about the prison law clinic at the University of Manitoba and the University of Manitoba Community Law Center. So what I'd like to do in the next 20 minutes or so is introduce the UMCLC's prison law clinic, talk about some of the trends we are seeing in Manitoba penitentiaries, and notwithstanding that I have a bullet point about thinking about things to think about for clients who are likely to be incarcerated, I probably won't get into that part of it. In terms of the UMCLC and the prison law clinic, the UMCLC's mandate is to provide high quality legal services to clients, to provide meaningful opportunities for students to develop their practice, and to assist enough clients to support funders' investment in UMCLC. We started in the basement of Robson Hall. For those who aren't from Manitoba, that's a law college here, and we've been part of Legal Aid Manitoba since 1972. Historically, UMCLC has focused on criminal law, but over the last 10 years or so, there's been a decline in criminal case numbers for all sorts of reasons, and so there's a movement into other areas of law. In 2022, the Legal Aid Manitoba and the Faculty of Law came to a memorandum of agreement contemplating expanding services, including into prison law and also family law, assisting lawyers in the north, assisting with appeals and things of that nature. This year, there was success with the Manitoba Law Foundation and a pilot project for the prison law clinic, which began in earnest in spring of this year. So as background, I suppose legal aid has historically represented inmates on disciplinary charges and in some cases at parole hearings. Moving forward, unless choice of counsel applies, these clients are represented by the prison law clinic. In terms of the other sort of work that we're doing, we do work in habeas corpus, human rights, grievances, mandamus, release applications, especially Section 84 applications, conditions of release, discipline, and parole and release suspensions. And I'm going to go into each of these areas a little bit more. First off, habeas corpus. This is one of those things that a lot of people have heard of, but most people don't have a very good idea of what it is or how it works. In Manitoba, certainly it's underutilized, but it's a potentially very powerful process. It has historic roots in medieval England. It literally means bring the body forward. And the idea is, the historic idea, I should say, is that it has to do with wrongful incarceration. So someone who's been entirely arbitrarily detained. The modern use varies, and there's a number of things it can be used for, but the most common use is to challenge security placements. So classic example, someone's in medium, they get maxed, habeas corpus may be something that gets used. To use habeas corpus, how it will work is the applicant will have to show that there's a deprivation of liberty, and then the burden will shift to the Crown to show that that deprivation is reasonable. When I talk about a deprivation of liberty, I don't mean the conviction itself. We are usually talking about either the initial deprivation, such as getting assigned maximum instead of minimum, a change which increases deprivation, such as, again, moving from minimum to medium, or continuing deprivation. So this is if you've been in medium for a long time, but you never should have been there. So for the lawyers who are listening, what this means is that even though you should probably move reasonably fast on these because liberty's infringed, there's a fair amount of flexibility in terms of when you file. The other thing I'll note about this sort of liberty concept is that it applies to lateral moves as well as horizontal, meaning that if you are in a medium institution and you're transferred to a different medium institution where you have less liberty for whatever reason, maybe it's the institution's practice or whatever else, then you can still bring habeas corpus. So it's not the designation that matters, it's the conditions of confinement. As I mentioned, once you show this initial deprivation of liberty, there'll be a switch to the burden on the Crown, who has to show show that it's reasonable. Really, habeas corpus is its own thing, so it's a little bit dangerous to go into parallels into other areas, but the easiest parallel is administrative law. So you have procedural fairness, maybe there's not enough notice, maybe there's not enough disclosure, bias, lack of reasons, these sorts of things, and reasonableness. So again, bad decision, unjustified decision, those sorts of things. When we're talking about human rights in prisons, this can be a challenging remedy for all sorts of reasons, like courts, administrative tribunals are loaded up with delays and in many ways are more bureaucratic and procedural than they're intended to be. That said, one of the benefits of a human rights application is that you're making a first decision instead of reviewing a decision, and you're going before someone who has human rights training and understands human rights framework. So that can be a useful approach. For incarcerated clients who are self-representing, it's relatively accessible, but that's not to say it's not very challenging. Mandamus, this is one of those things that I, at least in my practice, never really think about it or use it outside of prisons, but even basic rules sometimes need a mandamus application to be enforced. So by way of example, I've dealt with situations where there's a consistent delay in having a decision made, and the decision is supposed to be made within certain timeframes. At a certain point, you can bring a mandamus application to address that. It can also be used creatively for more complicated situations. So we once had a client whose name needed to be changed, and we did a mandamus application to Vital Statistics because under normal policy that didn't really apply to prisons. They wouldn't have been able to change their name. There's all sorts of release-related applications and processes. So release applications, conditions of release, and parole and release suspensions. We're particularly interested in Section 84 releases. These are releases into Indigenous community, such as Winnipeg, and appeals of these decisions. In terms of the conditions, we'll sometimes either appeal a condition that's been made or make submissions that a condition should not apply. So this applies most often to residency conditions. People don't want to live in a halfway house. Halfway houses function a lot like penitentiaries, and in some cases, that can be addressed. Parole and release suspensions are very difficult to challenge. So this is a situation where someone has been released into the community. They are on parole or on stat release, and then that parole or stat release is suspended. They get taken back to prison, usually the penitentiary, right away. The parole then, corrections then has 30 days to decide whether or not they are going to keep the person behind bars or whether it's a temporary suspension. And because of that 30-day period and just the incredible discretion that corrections has, this can be really challenging to review. We have seen lots of cases where people's release is suspended because their attitude has deteriorated, which is just one of those things that's like very challenging to meaningfully put into words. The other area is on this slide is discipline. As I mentioned before, Legal Aid's always done some disciplinary charges. We're doing more now. Some of this is in relation to getting into minor charges, and some of this is in relation to appeals. I feel like I should note that there was a duty counsel program, which was unilaterally scrapped, and we frankly haven't ever really got a satisfactory answer as to why it was scrapped. Where we're doing this right now, our funding is limited to federal institutions. So primarily this is Stony Mountain. For those who are not from Manitoba or who aren't familiar with Stony Mountain, Stony Mountain is Canada's oldest operating penitentiary. I haven't been able to figure out where it ranks, but I think it must rank as one of the oldest in the world, and it imprisoned people in the Northwest Rebellion, just to give some context to its age. Even though we are mostly working at Stony Mountain, we work with people who have a connection to Manitoba, but who are incarcerated elsewhere. So this might apply when there's, for example, women who get sent to Edmonton Institute for Women. May also work with folks at Manitoba Healing Lodges, and we're working to expand into provincial prisons, especially the Women's Correctional Center. Like the rest of UMCLC, for those who are familiar with it, we operate under a student model, meaning that students handle files under the supervision of a practicing lawyer. There's all sorts of reasons for this. One is that it gives the students experience, and it's meant to alleviate case burdens and allow lawyers to be in multiple places at the same time. Unlike the rest of UMCLC, we do have a staff lawyer, which is me. There are a few reasons for this. One is that practicing prison law requires that you do things that students can't do. If you're going to do a disciplinary proceeding, you should be prepared to JR it. And the other reason is that this way we can build longer term relations with the prisons and understand their bureaucracies a little bit better. For those who are in Manitoba or working with folks in Manitoba, there's really only one takeaway on this slide. Reach out to us with prison-related problems. If you're a lawyer or a legal advocate or something along those lines, we're happy to talk through what some options are, or commiserate about the frustrations around not feeling like you have good options. And depending on the situation, you may be able to refer to your client to us as well. I'll skip this. In terms of contacting us, reaching out to me, leaf.jensen@umanitoba.ca, or easier to remember, legalaid@umanitoba.ca is a great option. And then we'll also put the 1-800 number in the chat so people can see that. Now, I'll talk a little bit now about what we are seeing at Stony Mountain in particular, and the trends and problems, especially around access to justice. So the first problem we're having is around just getting documents. So prison produces a report about our client. We'd like to see that report sometimes. This is so much harder than it should be. It's an ongoing theme that we've certainly seen in the library's discussion, where it's just like, it's harder than it should be. We've spent a lot of time talking through this problem. Stony Mountain, to their credit, does recognize that it's a problem. Not so much to Stony Mountain's credit. The solution that they've provided has so far made it work, and it's something that we may need to litigate because they do have an obligation to facilitate access to counsel. Yeah, again, I won't go into too much, but this sort of frustration around just getting very basic rights and very basic things to happen, as we heard with the library's discussion, is an ongoing issue. I mean, as another example, I get told, I don't know how many times a week, but several times a week, that someone wasn't allowed to call a lawyer when they wanted to, really basic things like that. In terms of the disciplinary regime, basically there's two problems. One is that it isn't very fair, and two, they don't use it enough. Objectively, or what I call objective factors, it looks like it should be pretty close to criminal law. You have an independent chairperson, and you have the standard of beyond a reasonable doubt, which isn't the case everywhere in the provincial system. It's chaired by correctional staff, and they use balance of probabilities. The independent chairperson at Stony Mountain is the same person typically. He's been doing it for quite some time. He has what he calls a common sense approach, and he's noted that he can tell from body language when someone enters a plea whether they're guilty or not, which is, if it's true, an amazing talent, and frankly, he's wasted in his current position. As a practice note, he doesn't really appreciate case law. It's not a useful approach. The preferred approach that he's pretty blunt about is to sit and discuss the situation and come to a common sense determination. While that may be frustrating, like I say, the provincial system is chaired by correctional staff. The first time I did a disciplinary matter in a Manitoba provincial prison, I was trying to get a hold of the chair, and everyone who I talked to referred to them as the sentencing coordinator. not the discipline coordinator, but the sentencing coordinator. And it's like, feels like you might have skipped a step. So that says something about the way that, and I should say too, that's not actually their job title, that's just what they're known as, but does give you some sort of hint as to how that process looks. Specific problems with the disciplinary regime, there's lots of them: unreasonable delay, difficulties understanding what beyond a reasonable doubt is, overcharging, illegal searches, and others, but those are sort of some of the bigger ones. Now, even though, as I say, the system isn't very fair, the second issue is that the prison doesn't use this system enough, because while it is problematic, it does have procedural safeguards. What we find happens a lot is so-called administrative actions are used in a way that feels like punishment. So you might have a fairly trivial infraction, which has no link to visits or drugs or anything, resulting in a suspension of all visits for a month and a half. A month and a half is sort of the standard time. And the punishments that get used under administrative justifications tend to be worse than the punishments which would be available under a disciplinary process. Classification. So here I'm talking primarily about security classification. That is a point-based system, and it judges whether or not you're going to wind up in max, medium, minimum. They have a lot of other tools which are similar ones, which are used for risk of future violence, escape risk, all sorts of things. If you name it, there's some kind of tool for it. Now, in 2018, there was a Supreme Court of Canada decision called EWRT, which said that some of the classification tools used are not useful or appropriate for Indigenous offenders. And in the years since EWRT, that system still hasn't been replaced. If you're interested in that and in the law on classifications, keep an eye on the Dorsey decision out of Ontario. Leave to appeal to the Supreme Court granted just within the last month or so, so it'll be a little while, but it's about whether these security classifications can be challenged via habeas corpus, so it'll be interesting. Programming. Mark already talked a little bit about some of the realities around here, and that there's a pan-Indigenous approach. One could argue that it's worse than pan-Indigeneity. The Office of the Correctional Investigator, which was raised earlier in their 10 years since Spirit Matter report, they noted that what corrections really does with some of their Indigenous programming, such as pathways, is that they choose what the OCI refers to as an approved version of indigeneity, and that's what that program looks like. Pathways is the main program for Indigenous folks. It's the main cultural program. In Stoney, it's a unit instead of a program, which means that if you're not in Unit 1 medium, you don't get pathways. So if you're moved out of it for one reason or another, you're out. You have less access to smudges, less access to elders and things like that. And as the OCI also noted, there's a lot of problems with this, and with the whole notion of corrections having power over who qualifies for healing and who qualifies for cultural services. Just on the last couple minutes here. So in terms of drugs and cell phones are a major problem at Stony Mountain. The corresponding problem for us is that procedural fairness related to drugs and cell phones are major problems. People will often be told, well, we think you're involved in the drug trade, and not really provide enough to respond to in terms of saying how we think that. And so it's very vague. It's hard to respond to or challenge your allegations against you. If you look in the news or in reports that are generated by prison, they'll often refer to the institutional value of drugs. I don't really know how they calculate institutional value. What I do know is that when I've looked at marijuana and they say it has an institutional value of so-and-so, and then I compare that price to the price that I see at an online store in Winnipeg, the institutional value seems to be between 76 and 150 times the dispensary cost. In other words, if you spend $1 at the weed shop down the street, that will be $76 to $150 of institutional value. Conditions of release, again, major problem that we just see. The parole board hearings usually fail to meaningfully address or engage with the Indigenous social history, as they put it. These are often for anyone who's familiar with Ipoli and Gladue type things, you'll see that here too, where a lot of these factors are actually used against the person, and they'll say things like, well, this provides useful context, but that's not really what we're concerned with. And we also see conditions of release that effectively mean that your ability to engage in cultural practices in the community are restricted. And with the last minute, two more actually. In terms of provincial prisons, we've heard about access to literature and access to books being a problem. I mentioned some of the problems around disciplinary boards. And another problem is just medication, and medication is a problem in penitentiaries too. It's particularly difficult provincially because it seems like there are different standards at each institution. So you might have access to a medication in one prison, get transferred to another, and your medication is cut off because of the different policy. So this is obviously a pretty significant issue for those impacted by it. The last sort of overarching problem is just a real problem around access to justice. Like I mentioned a minute ago, pretty much multiple times a week, someone will tell me that they weren't allowed to make a lawyer call. And there's just so many little interactions, or if you're a guard, you might think of it as a little interaction. And it festers with people. It frustrates people to not have an outlet. And all the way back to the 1938 Archambault Report, a Royal Commission on Prison Issues at the time, we see them saying if someone feels they're unjustly punished and there's no fair chance to defend themselves, it leads to problems. And that's very much still a problem that we're seeing and dealing with today. So that's it for me.
Thanks so much, Leith, and thank you to all of our presenters. We have a few questions that came in through the chat. I wanted to first, Kirsten, I think you were answering in the Q&A itself, but I wanted to give you an opportunity to answer the questions about opportunities to donate books either to the Prison Library Committee or otherwise, and if there's a specific list.
Yeah, I did share our donation page. It's a tricky thing because we are a volunteer group. We sometimes get a lot of unsolicited donations, and it takes a lot of our time to go through. So the list, we keep updating our page and with exactly what we want, and we need to be able to sort of see what kind of titles, and they have to be newer and that sort of thing. So I'll share it in the chat too, I guess, the link, because we are very grateful for donations, absolutely. But just to give a little bit of a heads up, there's a bit of a process for it, so that we can get, yeah, exactly the books that are needed, and that it doesn't take up too much of our resources to kind of go through the books that we don't need. So, and there was also a question about audiobooks as well. And I just wanted to say that this is something we keep bringing up, because for accessibility, it's such a huge thing. Most of the audiobooks are on CD, so we're not allowed to bring those into the provincial institutions. And any other sort of technology, it's just not, it's not feasible. With this, they are doing like a tablet pilot project through the remand. Sometimes I'm hoping that perhaps we could do something with audio there, but my hopes aren't really that high. This pilot project's been going on for a long, long time, and I don't know how many people will actually benefit from it. And it costs money too. So that's the other piece.
Yeah, thanks, Kirsten. There was a question about whether presenters were going to be addressing Section 81 facilities. Those are the where Indigenous communities an agreement for them to have programming. Mark, you spoke a bit about them, and I think we did briefly. I just wanted to give folks an opportunity if there was anything more that they wanted to comment on specifically with respect to Section 81 facilities.
Yeah, I can just briefly add that there's 10 of them. There's 4 that are run by Correction Services, and 6 that are run by community or partner organizations. And they're sort of across the country in different stages. But yeah, that was a direct relation to the call to action, is my understanding. And so there is support for those healing lodges. But again, obviously we need more services, and we need basically the entire justice system to understand that they exist and what they are, and how we can utilize them better at all stages, not just at parole, but for diversion and for sentencing.
And I just add that similar to basically any of the time, there are resource allocation issues and specific difference-based needs to be met when it comes to Indigenous folks, that there's an incredible disparity in terms of the resources that will go to corrections in terms of Correctional Services Canada versus the resources that will go into community to provide the same service. So there's a huge imbalance there. There was a question I just wanted to raise because it gives me a chance to remind folks about, the prison law clinic. Someone asked about having a South Asian client who is looking to acknowledge Diwali, who'd been referred to a chaplain and hasn't been responded to. And Diwali, we know, is quickly approaching. I offered that one approach would be to connect with directly with LEAF and with the prison law clinic. These are exactly the sorts of conditions of confinement issues, access to recognition of one's religious observances, that we can potentially assist with. But I wanted to throw it to the group if there are any other ideas or guidance that folks might have. If anyone wanted to add anything, I didn't want to just kind of scoop it over to our clinic and leave it at that. I'm just checking there. I think we've answered most of the questions, all of the questions that have come in through the Q&A box. We do have a little bit more time, and I did want to ask Leaf, you had some comments that I think time willing you were prepared to offer when it comes to those practicing or interested in criminal law and some of the specific sentencing considerations in terms of kind of thinking ahead to what prison looks like for folks. Would you mind just briefly chatting about that a bit?
Yeah, absolutely. So just a couple things to keep in mind. I'm sort of envisioning these comments directing this at defense lawyers. Couple things to think about. One is sort of under the category of being client-centered. Just think about your client, think about their relation to prisons and penitentiaries. If there's someone who's never been to a prison or penitentiary before, they might need a little bit more time and some kind of guidance, connecting them to any resources that you might have available about what this is going to look like and ways to prepare might be useful. Another thing to think about is when you're negotiating sentences, think about breaches and similar offenses as more than a bargaining chip. The reason I say this is that I think there are sometimes when you have a list of 10 offenses and the sort of system generated breach looks a lot less important than the substantial offense, and often it is, and that's fine. But just keep in mind when you're having those conversations that years down the road, it's something that the parole board is likely going to look at a lot more closely than the courts do, because they're thinking, is this person a danger? Are they going to follow our conditions? And that may come back to haunt, guilty pleas on breaches may come back to haunt them. Other things to think about is if your client is currently in jail, either they've been denied bail or they're in the penitentiary and have some other charge coming up, whether the penitentiary has documents that might be useful for you. So talk to your client, talk to the case manager or the PO. If you can, get their most recent correctional plan or psych report. Documents along those lines will outline information about them, and they may be useful for you if it does get to sentencing. If you can say, well, they've taken these programs and here's the evidence of that, they've haven't had any disciplinary offenses, those sorts of things can be useful. And then the last thing I'll suggest is thinking about whether you can make your client's life better while they're in prison. And this is tricky. Sentencing judges can make recommendations. For the most part, these are non-binding, but you might be able to get a needed accommodation on the record or something along those lines. And sometimes this can be relied on by the parole board years later. And I guess the last thing I'll say is if you're interested in the sort of academic views on this, Lisa Kerr has an article about resisting black box sentencing, which is very useful.
Okay, thanks very much, Leaf. We've just got a question looking for some comments or insights on the connection between reoffending and books. leave for Kirsten or really any of our panelists, but I'll maybe throw to you first.
So like the recidivism rates in terms of like if they have access to libraries, if that affects. This is something that I've had lots of conversations with Howard Sapers about, who was the former correctional investigator. And I don't think that there's like a lot of really clear research, but I think there's lots of kind of correlations that you can make from other research that if you can increase folks' literacy and access to information, then that will help them in terms of problem solving, legal issues, but also just other, the healing, other issues in their lives, which then can perhaps go beyond then as they re-enter the community. I mean, how I see it with libraries is that we are hoping that if we are able to actually create a space that mirrors what you would find on the outside, then the folks in the prison will interact with libraries. They'll figure out maybe what a library does and interact with the library workers. So then when they leave, they are going to know that they can go to a library and they can get all of those helps and assistance, and that can just continue on. They can get free library cards and programming for their kids and language learning and all of those things. So I don't know of any real research that sort of points to that, but I think it's I think it's fairly clear, muddily clear that I think it can affect recidivism in a good way.
Thanks, Kirsten. I'd just add 2 points about that. One is on some of the correlative factors. You can look to some of the research around social determinants of health and the way that like just creating health in a holistic sense, people have access to education, access to respect for their human rights, access to employment, you lift people out of poverty, you increase literacy rates, all of these aspects of what is a healthy being can also have that correlative effect of reducing interactions with the justice system. And then the other thing I would add is I think that Kirsten is really underselling the incredible role that librarians play in our broader communities. And so I just wanted to also, in that like connection, when we're setting people up to come back into community, understanding that the library isn't actually just only about reading books. That's obviously a big feature of it and an important part of it. But the reality is that as our social safety nets become more fractured, libraries end up becoming a really incredible hub for people to connect, to have that sense of community, to access supports and services. And certainly in Winnipeg, we've seen some really interesting and fruitful experimentation with directly embedding social services within libraries as a means of actually promoting safety and security. And that can come with some pushback sometimes. So I think that those are things that we should resist. And also a big props to Kirsten and her group for the incredible work they do, so beyond the scope of any of their job descriptions.
But it's really fundamental, I think, to librarianship. But I also just wanted to mention that, yes, libraries are doing such incredible work. And I think one of the things you're probably referring to is community connections out of Millennium Library of the Winnipeg Public Library, which funding is finished for that by the end of this year. So this is something that's innovative and it works within the public library system, but the city has only funded it for 1 year. So there's a big issue there when things are working, but we're not getting the funding for it. Just want to mention that.
Yeah, and we see parallels in corrections so often. Mark, you had your hand up.
Yeah, just to this point as well, part of the collection and the Big Joe collection is culturally relevant books. So it's an opportunity for inmates to reclaim their culture, maybe for the first time for colonization. And like our education system didn't do a very good job of incorporating Indigenous ideas and worldviews. We're doing a little better now, obviously, but it's still a long way to go. And as noted in Kirsten's presentation, people asking for language books and books that will help them teach their own language. So it's an opportunity for folk to connect with their community and culture and themselves, probably in ways that they might never have had before, especially if they grew up in an urban setting or in a CFS situation. And just on the dream interpretation, we have to remember too that from an Indigenous legal order perspective, that dreams are sacred and can contain teachings and knowledge. So while it may seem odd in a new agey sort of way for dream interpretation, there is also a legitimate cultural need for dream interpretation books from that Indigenous perspective that talk a bit more about prophecy and that sort of thing. And just as a note on that, that the Turtle Lodge in Seguin was created after someone had a dream and a vision of that project. And so these things are another way and another hook for Indigenous folk to connect with themselves and their communities. So that's why this is so important. And that will obviously lead to less recidivism rates once we empower our communities to bring back the bodies that the state keeps moving into these systems.
Thank you. Yeah, and so that, I mean, I think that's a great, I don't see any further questions in the Q&A box. The chat's become, in addition to tech use, some places that folks are popping links. So that's, be sure to check that before you log out. This has been a really helpful, I think, conversation, really giving us a bit of a lay of the land in terms of what to expect in dealing with corrections. And in advocating for folks who are incarcerated, but also giving us some bigger things to think about and where those advocacy efforts could go further, as well as some tangible things that we can do when it's thinking about like, book donations or programs to support, or where we can link people with existing services. So I wanted to thank all of you, our panelists, for sharing your knowledge, and all of you who chose to attend. It's a fantastic. We had over 200 people register for the thing. We had over 150 people joining us live online. That's a really fantastic showing for folks that can often be very forgotten about, right? Out of sight, out of mind. And that's the thing that we really want to guard against when we're talking about these issues. So just in terms of final housekeeping, a reminder to all the Manitoba lawyers joining us that this program offers 1.5 hours of CPD credits, including, like, all of them can go towards your ethics, professionalism, and practice management hours. I'm sure with that, that there are other folks outside of Manitoba that I don't know the accreditation process, but you can look to that, and you'll know your rules better than I do. But be sure to check out also other Access to Justice Week events taking place across Canada. I did want to give a shout out to a couple of upcoming events here in Manitoba. Tomorrow's session is on victim impact and community impact statements, and you'll be able to hear from a panel of criminal and prosecution lawyers, criminal defense and Crown prosecution lawyers. And then Thursday's session will tackle family law services and pathways to a healthy separation. I think that there's a question about whether there'll be a recording, and I believe that it is being recorded, and I believe that those who registered will get a link to the recording of this presentation. So again, thank you all. Really appreciate everyone gathering. Mark?
And just before we go, I want to give a shout out to Natasha Brown, who's doing great work on justice here at Robson Hall. So if you have any general access to justice questions or want to know about our programming, I believe we have a blog on the website now, and if people want to join the listserv, reach out to Natasha Brown, as Robson Hall is really trying to become a hub for all these issues.
Yeah, and the website that we put into the chat about where the bios are located, that is that bigger Robson Hall and Access to Justice webpage that Natasha helps to facilitate. So again, a big thank you to Natasha and all the folks working with her on Access to Justice. Okay, thanks everyone. Have a great rest of your day. Thank you.